Justice Bose has agreed to deliver a lecture discussing constitutionalism in the contemporary world. But before we move to and invite Justice Bose to deliver his lecture, may I please invite Professor Nidhi Sharma, Assistant Director, the Center for Constitutional Law Studies, to the dais.
Thank you, Saib Noor. Good afternoon, everyone, and thank you so much for joining us today. I am Nidhi Sharma, and on behalf of Center for Constitutional Law Studies, it is my great pleasure to extend a warm welcome to all of you to this August gathering, to the distinguished public lecture on constitutionalism in contemporary world, which will be delivered by Honorable Justice Aniruddha Bose today. He is the judge of the Supreme Court of India, and before I invite Professor Srijit to the dais to welcome him, I would like to take this opportunity to say a few words about our guest of honor today. After practicing as an advocate for a period of 19 years at the Calcutta High Court, Justice Bose was appointed as a permanent judge of the High Court of Jharkhand and High Court of Calcutta. After that, he was elevated as the Chief Justice of Jharkhand High Court in the August of 2018. He has been serving as a judge to the Supreme Court of India since May 2019 and has authored significant judgments developing the jurisprudence on criminal law, family law, constitutional law, and service law jurisprudence. His contributions in the celebrated judgments like decriminalization of adultery, recognition of right to die with dignity as a fundamental right, the Jellikattu case have been material in initiating a constitutional dialogue on the right of self-determination and religious and gender justice. We are indeed privileged to have the Honorable Justice Bose with us today on the campus. The Center for Constitutional Law Studies seeks to initiate a discourse on important and contemporary constitutional law issues and to create a forum for a dialogue with honorable justice from India and South Asian regions. Constitutional litigators, scholars, and I'm sure our faculty and the students will be benefited by the discussions today. Through such debate and dialogue, we hope to develop a more rigorous, global, and interdisciplinary understanding of important constitutional law concepts and case law. Justice Bose has very kindly agreed to deliver a lecture today on the campus on the intersectionality of constitutionalism and democracy, especially in jurisdictions without a written constitution. I'm sure our audience today will be greatly benefited from the ideas and lived experience of Justice Bose, gained through the long and illustrious career, both as an advocate and the judge of the High Courts and the Supreme Court of India. On this note, I would now like to invite Professor Srijit to the dais to formally welcome Justice Aniruddha Bose.
Good evening, everyone. I stand here with great pleasure and honor at this special event organized by Center for Constitutional Studies. I'll speak about the Center for Constitutional Law Studies anon. But before that, I take this opportunity to extend a very warm welcome to Justice Bose to Jindal Global Law School. It's heartening to know that this is his first visit. I'm sure there'll be many more visits forthcoming. Now, the Center for Constitutional Law Studies, initially, you know that this center was very much sleeping inside the Center for Public Law. But at some point, we felt that we need to create a mutation of the Center for Public Law so that there is much more dedicated conversation on constitutional law, because we live in an age of constitutionalism. There is need to reinvent that faith which probably we lost somewhere in the Constitution in the maelstrom of time. And hence, the center got mutated. The Center for Public Law got mutated, and this new mutation is the Center for Constitutional Law. And of course, it has definitely not led to an osmosis. That Center for Public Law still continues to function in all its vitality, but Center for Constitutional Law has in fact become a new medium to discuss extraordinary imaginations on the constitutional law, including constitutionalism, popular constitutionalism, critical constitutionalism, and the very idea of India as it's ingrained in the Constitution of India. Now, this is a topic which certainly is close to my heart, even though I'm not a professor of the constitutional law, because constitutionalism is a faith. it's a faith, and it's a hope. Now, we have titled this session Constitutionalism in the Contemporary World. But the question is that why should we speak about constitutionalism, or why constitutionalism is something which is worthy to be spoken about? How do we define this? Well, if I may loosely do that, it's a subconscious faith in the rule of law. It's a subconscious faith in the possibilities of law. It's a subconscious faith that Constitution has that magic mantra to recreate our own realities. So whenever we feel desolate, whenever we feel vacant, whenever we feel dejected, whenever egalitarian promises fail us, we need to go back and read the Gospels of the Constitution, which tell us, which gives us a new hope to reinvent the nation, reinvent our own faith. Now, we live in a kind of a loss of memory. The loss of memory has happened historically. There's a popular novel by Kazuo Ishiguro with the title The Buried Giant. In the novel Buried Giant, everybody who lives in a certain valley has a certain forgetfulness, because there is a dragon lying somewhere out there in the valley which exhales a strange air, breathing which the entire valley is in a forgetfulness. We have many such dragons sleeping in the society which is exhaling certain gases, certain air, and we have breathed it, and we are in an abject forgetfulness. We need to recover that memory, recover the memory of our own identity, recover the memory of an India, recover the memory of a dream. And going back to the Constitution helps us recover that dream. So I said that this strange mist, if we have to overcome the overpowering sway of this mist, we actually need to read the Constitution, because in the Constitution lies the organic idea of India and all the associated memories. So Constitution is a historical document in that sense. Also, we live in a time when we don't believe in anything. We have stopped believing at the beginning of the 20th century, because Nietzsche declared the death of the God, death of metaphysics, death of philosophy. We spoke a lot about death, and we stopped believing in things. So we need now something to believe in. What do we believe in? Of course, you know that in order to believe in order to have faith, we do not have any gods left. And when I talk about the gods, I'm not talking about the gods of the prehistory or the proto-history. I'm talking about the God of the values. We need the new gods, the new values to invest our faith in. Constitution is that God. Now then comes the question, why is Constitution God-like? As much as God is the base imagination on which our reality is built, Constitution is a base imagination. It is the truth about a nation. Now, it is on this base reality that we are going to construct our dreams. We are going to discover, invent, reinvent, discover, and rediscover our own reality. Constitution is the base of the Indian existence. It is the domain of human socializing, and it is actually the very domain of all possibilities. So you open the Constitution, you open possibilities for a new reality. So the effort here, when we go back and talk about constitutionalism, we are trying to dispel that mist which has forged a forgetfulness in our minds. We are trying to bring back philosophy. We are trying to bring back faith. We are trying to bring back hope. And that's exactly conversation on constitutionalism gives us. We see a constructive anger in the society today, and especially among the young set of the scholars. If I may take a few names, Madhav Khosla, Tripur Daman Singh, Akash Singh Rathore, Gautam Bhatia, Aniruddha Chandrachud, Rohan Alva, you see a lot of angry writings. It's so refreshing to see the anger, because it is this anger which is exploring the possibilities of the Constitution. The young generation of scholars, they have started to think about what the idea of India is, what our reality should be like. It's their own effort to participate in the creation of a new reality. Well, this faith of constitutionalism, this small faith which they are showing through their anger, that's exactly what we need today. And definitely, this is also the first note of the recovery of that faith. And I'm sure that conversations on the constitutionalism will help us recover that faith, because faith will help us sustain our dreams. And of course, dreams do come true. So Constitution will help us fulfill that dream. Well, so much by way of a context. I don't stand between you and Justice Bose, who will speak out of his own experiences, his own value set. I once again take this opportunity to welcome him, and of course, the members of the delegation who visited the campus, my dear colleagues and dearest students, faculty members. A great welcome again to this special distinguished lecture organized by the Center for Constitutional Studies of Jindal Global Law School. Thank you.
May I now please invite Professor Sarbani Sain to make a few introductory remarks.
Good afternoon, and on behalf of the Center for Constitutional Law Studies, a very warm welcome to the Honorable Justice Aniruddha Bose, Professor Shujit, distinguished guests, faculty members, and students. Justice Bose will be delivering a distinguished public lecture titled Constitutionalism in the Contemporary World. In view of the depth of his experience and understanding of constitutional jurisprudence acquired through his years of practice of law and on the bench, we can think of no better person to deliver this lecture today. His judgments in cases such as the Animal Welfare Board versus Union of India, Joseph Shine versus Union of India, and Common Cause versus Union of India are evidence of his thinking on such important constitutional issues, such as the right to die with dignity as a fundamental right, the dignity of women and their capacity to make choices and have their own identity, and rights of animals under Article 21. The topic of the lecture focuses on a global understanding of the phenomenon of constitutionalism. Though there has been a rapid spread of the trend towards having a written constitutional document, a Bill of Rights, and powers of judicial review after the transitions to constitutional democracy in Eastern and Central Europe, and the writings of many constitutions in the 1990s, such as the South African Constitution and constitutions in Latin American countries, the concept of constitutionalism needs to be understood with more conceptual clarity and in a more nuanced way. So I'd like to very briefly highlight some problems or some points why we need to get more conceptual clarity in this area. Number one, the idea of constitutionalism is actually distinct from the idea of having a written constitutional text. This is because it is possible to develop a historical tradition for the enforcement and practice of liberal democratic principles, and thus have constitutionalism without even having a written constitution. The English Constitution being the most famous example. We also see this in countries such as Israel and New Zealand, which have uncodified constitutions consisting of cases and precedents, common law, and provisions of formal statutes. Conversely, countries with a written constitution and a written Bill of Rights may not always develop a tradition of constitutionalism, as is evident in the case of the sham or nominal constitutions of some African countries. Secondly, the second point on which we need clarity is because the understanding and development of important features which we associate with a tradition of liberal democratic constitutionalism differs so widely across countries based on their own historical, political, and social contexts. So ideas of social and economic rights, the scope of free speech, or the concept of secularism are all understood very differently in different countries. Institutional frameworks for a liberal and democratic representative government can vary from the Commonwealth model of parliamentary sovereignty to the US presidential system, the French semi-presidential system, or even illiberal constitutional systems. The scope of the power of judicial review can vary from the strong form judicial review in the US and India to the dialogic model of review in South Africa. Judicial standards of review can vary from strict scrutiny standards of the US Supreme Court to proportionality standards used by the German Constitutional Court, or the reasonable classification test or arbitrariness standards used by the Indian Supreme Court. Amendment procedures can also vary from rigid formulas for amendment to tiered formulas for change for different provisions of the Constitution, as in India, and also extend to entrenched provisions in the Constitution, as in Article 79, Para 3 of the German Constitution. Lastly, another reason why we need some clarity is because the scholarly and methodological approach to understanding constitutionalism has expanded enormously. It is now increasingly an interdisciplinary and comparative field, engaging the expertise and insights of judges, litigators, and scholars from different fields to develop a more insightful framework for analysis and understanding of this concept of constitutionalism. Hence, I feel that Justice Bose's lecture is very timely and will be of great interest in developing our understanding of the concept of constitutionalism in a global context from a judicial and scholarly perspective. I would now like to invite Justice Bose to deliver his lecture.
Thank you. dear students, faculty members, and Professor Srijit, Professor Sen, Professor Sharma, Nidhi Sharma. Thank you for reposing a lot of faith in me, for demystifying the philosophy of constitutionalism. I hope I don't generate more confusion than it already prevails in many of our minds already. I'll try in my own way to understand and share with you what constitutionalism means, how is it different from constitution, and where is the necessity of having a constitution. In one of the, now of course first point of reference is Google. So I was going through it on this constitutionalism and constitution, and somewhere I found a line that average life of a constitution is 17 years. I don't recall the reference, so I haven't used it in my piece. But well, we have done slightly better than that. Now, the suffix ism normally represents an amalgam of ideas and practices to which its followers strongly adhere to. You have various isms everywhere. But when we talk of constitutionalism, in my understanding, it primarily implies adherence to something called rule of law instead of any particular form of a political or religious philosophy or idea. It lays down a framework adopted by a democratic country and represents an idea under which an elected government is tied to a set of norms and standards which is equally applicable to all, barring some exceptions. The core norms and standards remain unchanged even when people vote out a particular government or elected body and replace them with another. Constitution by itself is an instrument for controlling or regulating state power, apart from setting up a mechanism for governance. It is not a cosmetic term that can be altered at the will of even an elected body, and it incorporates many ideas coming down to us over centuries and embedded in the very concept of rule of law. And here by rule of law I don't mean court-oriented rule of law, but a rule of law which is applicable across the organs of the state and not necessarily which is to be looked at when a lease arises. In pre- and post-Vedic India, the king used to administer justice with the assistance of legal advisors, primarily who were purohits or priests, and the Sabha and Samiti, which possibly represents the houses of elected bodies, trying to keep a check on power of the king. That goes very old, that dates back. But from the beginning of civilization, almost every society had some kind of norms. Now, what are the characteristics of constitutionalism? First, of course, there must be a constitution, ideally codified, though one of the oldest democracies in modern times chose not to have a written constitution. If we look at our own constitution, carrying more than 1.45 lakh words, It covers almost every feature of governance. It deals with powers and privileges of all the governing authorities. It lays down the relationship between the center and the states. It stipulates what would be the languages for the nation. It deals with the question of citizenship. But the most outstanding feature of our Constitution, I think, is Part 3, laying down the basic rights of citizens as also persons within the territory of this country, and an enforcement mechanism. We can approach the highest court of this country if there is a breach of any of the rights enumerated in Part 3. This, in my view, before me, Dr. Ambedkar had already expressed his view, so I wouldn't call it my view, that Article 32 is the heart and soul of the Constitution. Well, every civilized society used to run on some basic tenets which ultimately emerged as inalienable feature of governance, which we call rule of law. In Dr. Bonham's case, in 1610, Sir Edward Coke had laid down the dictum that common law shall control even the acts of Parliament. This was echoed later in the US when John Adams was writing the Constitution of Massachusetts in 1780. He wrote, "It shall be the government of law and not of man." The same expression found way into our constitutional jurisprudence in a 3-judge bench of a Supreme Court in a case Eurasian Equipment Chemicals in 1975. Sir Edward Coke's opinion, I think later on he became Lord Coke, however, stood diluted to a large extent in England when parliamentary democracy flourished, but resurfaced in the US with Marbury versus Madison. I'm not giving particulars of this case because these are elementary cases in constitutional law. Much later, Lord Coke of the Court of Appeals of New Zealand, at that time he was not Lord Coke in all probability, in a case carrying the cause title Taylor versus New Zealand Poultry Board, he had observed in 1984 that some common law rights presumably lie so deep that even Parliament could not override them. So, in common law, though it speaks of parliamentary sovereignty, there are limits on even parliamentary powers. In fact, across the globe, there seems to have been some kind of realization among the democratic countries that even in the legislative field, some kind of control by an impartial tribunal would be necessary for preserving the rule of law. Without providing for basic rights which can be enforced, a constitution granting such rights becomes a tiger without either tooth or a claw. A constitution of erstwhile Soviet Russia had all the basic rights, that is in 1936, but there was no enforcement mechanism, or it had a very weak enforcement mechanism. At present, unfortunately, in various parts of the world, a tug of war is going on in countries with borderline democracy between autocratic and democratic line of political thinkers. In many cases, the central line is in the process of being redrawn in this game of tug of war. We have to wait and see on which side the central line shifts. The main critic against a review of legislative or pure executive action, which I call is the essence of constitutionalism, is that how the set of unelected members, usually much lower in number than elected members, can sit on the will of the people. Secondly, in the field of policy making, without any ground level experience, is judicial review a feasible option? The other criticism is based on the functional aspect in implementing a judicial decree. In the celebrated judgment of Brown versus Board of Education, when the states, when Supreme Court wanted to implement this judgment in Arkansas, the governor refused to implement it. At that time, President Eisenhower, he sent federal troops to the Little Rock School, and the photograph is available on Google and everywhere. A set of gun-carrying army men accompanying a tiny little boy to a school. President Lincoln also had to suspend the implementation of the writ of habeas corpus in the troubled times of civil war. These are, however, aberrations. Reverting back to our constitution, as also constitutions of many other countries, types of rights that are sought to be protected, so far as human beings are concerned, are essentially that of liberty, protection against being confined to a legitimate or illegitimate incarceration, place of incarceration, and property, protection of property rights. From the beginning of our democracy, this two conflict areas emerged and reached the Supreme Court straight away. Imposition of preventive detention laws in 1948-49 gave rise to the cases of A.K. Gopalan on preventive detention, right to form association in the case of B.G. Rao, whereas in state of Bihar versus Kameshwar Singh, compulsory acquisition of property was held to be permissible, applying the principles of eminent domain. Thus, the Constitution in many ways adjudicated disputes based on age-old principles. The doctrine of eminent domain nowhere finds mention in our Constitution and suggests the state to be the ultimate owner of all lands within its territory. Okay, this concept goes back to 24 BC, when a ruler called Urukagina, he was the ruler of the city of Lagash in Sumeria. He was possibly also the first social reformer in the field of law. He had acquired lands from the princes and temples and distributed it among the less privileged. That is the source possibly of eminent domain. The expression habeas corpus is of 12th century vintage. whereas due process finds its mention in Magna Carta. So, constitutionalism is not something which suddenly was discovered by a set of political thinkers. It was not an invention, nor even a discovery. It was an evolutionary process which the civilized society accepted. Constitutionalism essentially implies holding the state accountable to certain norms. A new challenge to this concept arises as we are witnessing withdrawal of the state from many sectors which we have grown up thinking to be essential sovereign function. Well, education is one of them, and a lot of debate is going on from the Unikrishnan onwards to what extent this shall be regulated. And these private entities also exercise power to restrict access to the medium they control: electricity, railway, airways, spectrum. One extreme example in how these private entities kind of acquire and exercise this power is that of a social media platform censoring the head of state of the most powerful country of the world. I think WhatsApp or one of them just deleted. This was on the basis of their self-evolved rule without aid of any sovereign organ. Will this tool be safe to an entity who is primarily accountable to its shareholders? That's a question we'll have to address, and whether the constitutionalism, the concept, shall extend to this public platforms or areas which were essentially sovereign in nature. That's a question we'll have to answer. We have some answer in case laws where private entities discharging public function has been held to be accountable to the extent of preserving the constitutional rights. We have referred to various examples in which judicial intervention has been justified. And in my view, this is the very foundation of what we are discussing today. But we cannot escape the criticism that it is too risky to leave such policy-making power with an unelected body who doesn't have to face the people on a regular basis to justify their existence in that position. So far as limits of the state power is concerned, there are several reasons to justify that. First of all, in most of the democracies, people elect the government for a limited period of time, and within that spell, power is not given to them to permanently alter or interfere with well-established norms. That is the concept of basic rights. Many of the democracies wrongly treat basic rights as a gift of sovereign, which carries with it the implicit thinking that whenever the sovereign feels, these rights can be withdrawn. That is probably the Norman view, which came in England with 1066. The contra-thinking, which was possibly Anglo-Saxon view, is that fundamental rights are inherent and inalienable, and a person acquires on just being born, and I am with Lord Cook on this point, none of the state organs can encroach upon them. In the Indian context, I am not aware of any study done about basic rights in the, at least in the pre-Vedic, post-Vedic period, from where there's some kind of documentation. Possibly greater study is required. But limits on the state power was always there. This, however, does not directly answer the question as to how and why an impartial tribunal, in most cases appointed by the state, but with an element of permanency, should be vested with the power to control the elected government in their dealings with the individuals. Here, possibly, one has to draw a conclusion based on evidence rather than any theoretical analysis. Oliver Wendell Holmes, the noted jurist and judge, in his well-known treatise, Common Law, wrote that life of law has not been logic, it has been experience. In fact, many European countries which opted for parliamentary sovereignty had to introduce the Human Rights Charter, which can be enforced through the European Court of Justice. Our own experience, which I guess, or my own experience, which I guess is the common experience across the globe, is that an independent judiciary has never been a threat to democracy. Rather, they have enhanced its quality and value. So that is the law experience which Oliver Wendell Holmes thought of, which may not be justified, or I don't think can be justified by logic. And that is what constitutionalism is all about. Thank you.
This mic is too short. Thank you so much, Justice Bose. Thank you so much for your lecture. I know you have some dearth of time and you have to leave a little early, so we'll maybe have 3 or 4 questions. And I will place a bid as the moderator to ask the first question. Justice Bose? If I may, sir, if I may address you. So, sir, the mainstream narrative on constitutionalism comes from this negative idea of restricting what the government can do. There is some new literature that tries to also explore the idea of constitutionalism as a tool to compel governments for the welfare of the people. In that dichotomy, how do you see constitutionalism in a society, sir?
See, entitlement rights, I guess that's what you were talking about.
Yes, sir.
For a long time was left to the domain of the elected government. I think we tried it for the first time with this P. Am I audible? Okay, this entitlement rights were not thought to be, it's part of constitutionalism, but not through the court of law. This was a view which prevailed for a long time, But then this PUCL case on right to food, that is a unique case which is largely ignored by the mainstream media, in which the courts are implementing right of hungry people to have access to food. So, as at the macro level, entitlement rights is, of course, part of constitutionalism. But if you see the Constitution, this entitlement rights are kept in Chapter 4, Part 4. And Part 3 rights are kind of spatial concept. You can't enter into this space, except for maybe 19(1)(a). That's where you can block expansion of something which I am saying. So yes, it's part of, apart from that, many other entitlement rights like prisoners' rights and are being implemented through court. But here also the court cannot replace the executive. So,
Thank you so much, sir. Now, any more questions from the floor? I see there's one hand raised here. Let's start with you. Just introduce yourself and then ask your question.
Yeah. Good evening, Justice Bose. My name is Aniruddha Srivastava. I'm a GGLS faculty here. I wanted to ask you a question regarding a recent literature. You might not be aware about it. So Professor Martin Loughlin, who was the outgoing chair of London School of Economics, he recently wrote a book called Anti-Constitutionalism. Amongst other things, in his book, he argues that nations such as India, who have a rigid constitution, rigid in the sense that it's heavily entrenched, and even rigid in the sense like the US Constitution that they're difficult to amend, they are kind of in conflict with constitutionalism. He argues that constitutions such as the British Constitution or such as the Israeli Constitution that Professor Sain mentioned are ones in which constitutionalism can best develop. So do you think that, would you agree whether or not constitutionalism and written constitutions are in conflict of some sort? Thank you.
well, firstly, you were right that I haven't read that book. And the British constitutionalism is also undergoing change with the Human Rights Act. In Israel, that basic law which has come, on that there's a lot of conflict. So I think the world is moving towards having a written text. So once I read the book properly, I may be able to answer your question. But that's one way of thinking. It evolves thinking. But then again, the US, with the minimal change, 70 years old precedents are also being altered without changing the constitution. So we also take care. Like initially in Gopalan, we rejected due process. But through Maneka Gandhi, again, we reintroduced due process or introduced due process. So it changes with time. Thinking also. That essential controversy about in the US that the conservative thinking that we should read Constitution as it was written in whatever the Bill of Rights in 1789, 1789, and today, and that debate is going on in the gun control law. So everything evolves. Human genius is, I think, much better in evolving things than a judge's brain.
Thank you so much, sir. We have time for just one more question. Actually, we've already overshot by a minute, but one last question if anybody has questions. Sure.
Good afternoon, sir. I'm Yashaswini Verma. I'm in BLLB first year. I wanted to ask, with regards to constitutionalism and the combination of that and judicial review, if we see, for example, a very recent case in Dobbs versus Jackson Women's Health, which overturned Roe v. Wade in the United States, wherein an independent judiciary took the decision to go back on an earlier decision through judicial review. How exactly do we look at decisions like that which go against certain precedents which are considered to be positive for society, or maybe anti-constitutionalism in that sense, because of the lack of democratic practices which might be reflected there? How exactly do we navigate the conflicts which come in terms of judicial review in cases like that?
In the US context, there can't be any judicial review over 9 judges of the Supreme Court. Then the Congress will have to resolve that dispute. And I personally feel the elected body should resolve these disputes, barring very few. And we should approach the elected body. See, one problem which I feel will plague us in future, a lot of political questions and socio-political questions are taken straight to the court by one group of people who think in that manner. There's not enough public debate. And if we try to interfere with these issues of general public interest at the instance of one group, they will have a bona fide interest in that. I'm not doubting that. Generally, the legislature, what will be their role? If every question is settled through the court for the first time, so ultimately you will have to approach the lawmakers. That is my own understanding. Because you can't ignore Parliament and
Any more questions from the audience? Okay.
Good afternoon, sir. I'm Manushree Sarkar, a first-year BLLB law student. I would like to ask you that, just following upon your answer, have you, as a judge of the Supreme Court and the various judicial bodies before that, have you felt restricted while giving a decision because you cannot make a law and it is up to the legislature to make a law? So while giving a decision in a court case, have you ever felt restricted in your capacity because you can only make laws through precedents in the Indian system?
I feel restricted all the time because Constitution has not given me that mandate. Okay. I'd like to do so many things, but I can't impose my own will on the people. I need a empowerment through a legitimate instrument.
Thank you, sir.
Is there any question from that side? Okay. Thank you so much, Professor Bose, Justice Bose. I would now like to invite Professor Srijit to present a memento to to Justice Bose as a token of thanks.
Thank you so much, Justice Bose. Thank you so much, Professor Srijit. I'll just take 2 minutes to also thank the number of people who put in their efforts behind the scenes to make this event both possible and successful. And I must start with Justice Bose's secretariat, led by Chandresh ma'am, who made the whole process of being a liaison between the global law school here and your office. So I must also thank everybody in the AV support team, in the events team, of course, the registrar's office, the vice chancellor's office, the chief proctor's office. And although we haven't had the chance to grab that high tea, but I also must thank in advance the food team for putting together what I'm sure is an amazing high tea. And to all of you who've spent their Saturday afternoon with us, thank you so very much. And let's just wait for Justice Bose to proceed towards the faculty office building before we start to also leave. Thank you so much, sir. Thank you so much.